come through, then you can just put it up again.
Yes, because I think that my colleague might need the slide to do his slideshow. Are my slides off the screen now?
Yes, yes, they are.
Okay, perfect.
Okay, welcome everyone. Everyone's here. Jennifer, Liz?
Yes.
Yes, yes.
Okay, good. All right, good. My name is Aslam Mullah. I'm an attorney. I specialize in labor law. And today I'm going to be covering a few of the important issues when it comes to employee rights in South Africa. It's a very short presentation, literally 10 to 15 minutes, and then maybe 10 to 15 minutes to answer some questions, and then we can hand over to the next speaker. All right, so I don't know if any of you know any of our videos from online. We have quite a lot of videos on employee rights and the way forward. But in a nutshell, can everyone hear us? Everyone is...
Yes, I don't think they will know you because you turn your camera off. If they can see your face, I'm sure they will recognize you.
Yes, I'm currently on vacation with my family.
Okay.
So,
all
yeah.
right, understood.
Yeah, I just agreed to, assist and do this because you asked me, and I also believe it's important to give back as well. So I can turn my camera on, but you won't see me in a suit. Let me see.
No problem.
There's the beach over there.
That's nice.
Right. Maybe I'll keep the camera on over there and you can just see. I'm not wearing my suit today. I'm just in a long sleeve. So everyone, let's start. Okay. My name is Aslam. Thank you for attending today. Let's talk about what you need to know. Can you guys still hear me? Because Jennifer's screen is frozen.
Yes, we can still hear you.
Okay. Good. I can see all the thumbs up. Now, I'm not going to talk about labor law because you study that in law school anyway. And that's not what you need to hear from me today. I'm going to talk a little bit about why is it important and what you need to know before you sign your articles, important practical tips when it comes to articles and things like that. So let's start off with, why do employee rights matter? Why should we have labor law in South Africa? Because some jurisdictions overseas, they are pro-employer, pro-business. So you look at, for instance, some Asian countries as well, there's no minimum wage. A boss can just dismiss someone if they need to fire someone. Here in South Africa, you need a reason, you need a procedure, you can get taken to the CCMA, pay up to 12 months compensation, minimum wage, contracts, all those things come into play. The reason why labor law is important is because it's called balance of power. And when you enter the workplace, you'll understand as an article clerk that you are entering the food chain at a small level. In other words, if you think about, on the coastline now in Durban, we are expecting to see the sardines today. Right? Anytime they're going to go past. They've been already spotted on the south coast and things like that. Sardines are small fish. Behind the small fish, you will get salmon, sharks, and that's how the ecosystem works. Now, when you enter the workplace, you can't enter as a CEO of a company because you don't have the experience to lead and manage an organization. Your practical work experience is quite small. As a result, because you need the job also, you can't easily negotiate the terms to say, listen, I want you to pay me this amount. I want a 2-hour lunch break. I want to do this. I want to do that. The boss will tell you, go and fly a kite. Someone else will come and join. I don't need to hire you. Does everyone understand what I'm saying? Just give thumbs up because I only see blank screens over here and I don't want the signal. Very good. So this is why labor law rights are important, because the employee does not have power in the workplace. The law will then give them the power to be treated fairly. Otherwise, things like discrimination happen, unfair dismissal procedures, harassment at work, all of those things will happen. So let us now talk about the basic employment rights that you need to know. Number one is the right to fair compensation, and this applies to you. Last year, I think the LPC had issued a minimum wage for article clerks. Does anyone know what the minimum wage is for article clerks? Can they speak, Elizabeth?
Yes, they can.
I don't mind a more interactive session. I don't want it to be a lecture. People will fall asleep otherwise.
Yes. Guys, you can interact, you can interject. So please.
Who knows the minimum wage for article clerks in South Africa? Jennifer, you can't answer.
Good morning. The minimum wage is now 8,000 rand for candidate attorneys.
Very good. I think it's in 5. Very good. That's a good answer. Maybe you can mute yourself. Just press mute because I think with the feedback, that's good. That is a good answer. So it is 8.5 or around 8K. Now, prior to that, there was no minimum wage. That means if you were working, imagine now you studied for 4 years. You went and passed all your exams. Now, all of a sudden, they are saying to you, come and earn 2,500. There are article clerks who are earning 3,000 rand. Today, the cost of transport is only that amount of money. So the government has introduced a minimum wage, so right to compensation. The next is the right to non-discrimination and equal opportunity. That is very important, especially when we look at the past history that we've had in South Africa, with equal opportunity to different racial groups. Now we have affirmative action. Recently, the Labour Court has said you can't have affirmative action where you exclude someone completely just because of their race. So all of these things are competing factors. Now, let's talk the next thing about employment contracts, what you need to know. Gabriella is doing articles. I don't see her here. But the employment contracts, you will sign 2 types of contracts when you do your articles. One contract is a contract you do with the LPC, Articles of Clerkship. And the other type of contract is an employment agreement, which you need to sign. You will probably sign a fixed term contract because it will only be for 2 years. After your articles, you will then proceed to either an associate position or whatever the case will be. When you sign an employment contract, there are some important terms you need to look out for. One is your job description. What is the company expecting from you? Next is your working hours and how much you're going to get paid. That's very important. Also look at the probation period. Usually companies have a probation period. Even in articles too, you can have a probation period. You need to be aware of that. Sometimes it can be 3 months, 4 months, etc. Let's talk a little bit about how to handle unfair treatment at work. So I'm going through the main issues because it's important for you to understand how you handle these things. This can happen to anyone. Give a thumbs up if you know of any negative stories that have happened to other article clerks or students when they enter the workplace. It can be any story negative. Either they were bullied, harassed, or whatever the situation is, they got fired. You don't have to share the story. All you have to do is give a thumbs up. So I just know that you're still listening to me. Elizabeth has given a thumbs up. There's a lot of thumbs up. Many people know Lungile, Telebochile. A lot of people know this. So how do we deal with issues like that? What if you go into an environment and you are being harassed by your colleagues, you are being harassed by your principal? What do you do about that? Does anyone know? Are you meant to keep quiet about it to protect your articles? Are you meant to speak up? What does a person do if they are being harassed as an article clerk? First, can anyone tell me what is the definition of harassment in terms of labor law? Does anyone know? Anyone wants to take a chance to guess? Elizabeth, you done compliance.
Good morning, sir.
I
Maybe
think-
I can just try. So what I think of or believe harassment can be is when you are compelled or forced to do duties which are not within your contract of employment. So yeah, I don't know, I could be wrong.
No, it's a good answer. Are you a third or fourth year student?
I am doing my 4th year.
Fourth year. You got articles next year already.
No, I'm still applying, unfortunately.
Okay, good. But that's very good initiative. Where are you based?
I am based at the Northwest University Potchefstroom campus.
Oh, okay. But I
Yes.
like your initiative. I'm very happy to see that. You just keep it up. Even if
Thank
your
you.
answer is wrong, when you do your articles, remember, I'm doing this for 13 years now. But when I started, I didn't know anything. Everyone, when they start, they don't know what to say, what to do, how to do it. But the important thing is you must be willing to try, even if you are wrong. And your boss wants to see you trying. Your boss wants to see you making an effort. So you go in and say exactly what you said now, Nick. Listen, I could be wrong, but I think the answer is this, this, this. That is a very good quality to have. Now, harassment would be any form of unwelcome and unsolicited treatment or behavior when received at work. There's Gabriella over here. Gabriella, how many articles, when you sign articles, there's 2 contracts a person signs, isn't it? One is in a contract with the LPC and one is an employment contract. And it's a fixed term employment contract.
Yeah.
Okay. Good. So coming back to the issue of harassment, if you feel that you are being harassed at work, and this could be harassment in a form of unwelcome behavior or any kind of behavior that is not professional, you have an option as a candidate attorney to report it to the LPC. Now, it doesn't mean you must, if your principal shouts at you and you get angry and now you're going to rush off and report them. It doesn't work that. You must allow for some leeway to have a difficult environment because that's part of your articles. You can't have your principal give you affection like how your mother and father give it to you. It is a business relationship, but at the same time, if your principal or your colleagues or anyone in the profession, magistrates, anyone is treating you in a way that degrades your dignity, speak to them first. Tell them that you're not wanting this. You don't want to be treated this way. Make sure you send them a WhatsApp, email, grievance, and then from there you can look at going to the CCMA or even the LPC. So that's how you deal with harassment. Now, I'm raising this because when I asked how many people have heard stories about harassment, the whole screen went up with thumbs up. So it's important that you understand what to do. Let's talk about tips for how to serve articles, and then I'll end off on questions. Now, the first important tip for articles is to choose the right firm. That means that choose the kind of firm that will align by your values and your career goals. That means if you want to do criminal law, don't go work for a labor law firm or conveyancing firm just to get your articles done, because 2 years, you will be getting a lot of experience in 2 years. If you want to learn, if you're not sure what area you want to specialize in, then join a smaller firm. You'll get to do everything, a smaller firm. My advice is for you not to specialize in your first or second year of articles, because you don't know what you like until you actually do it. It's very rare that in your articles, you will see something you like and you'll immediately do it. Like Gabriella started on labor law, and now she's only doing labor law. But she studied civil procedure and family law and things like that. So the idea is try and get diversified experience. Articles is the only time you will get away with errors and mistakes. It doesn't mean you must go and deliberately make errors and mistakes. It means that the LPC is not going to take away your license and punish you and for negligence, because you're still learning on the articles. So use that to do as many things as possible. Now, you should take on cases when you're doing articles. So whenever you sign up for articles, ask the manager of the firm or the director or the person you report to, what is your most difficult file? What is the file that you don't like to work on? Give me that file. They will look at you with big eyes because they want to know that who you think you are. You just finished your LLB. But it will show a commitment, and it will show that you are willing to go into the trenches and do what is necessary. Very important to build relationships in articles. That means that when you go to court, you might think it's only the judges and the magistrates that have the power. The real power is those admin clerks that stamp your papers and get your court date. Don't treat them with any disrespect. Make sure you talk to them nicely, become friends with them, because they have a big influence on the impact of your case. Also, very important is work-life balance. You need to avoid burnout, especially in your first and second year when you'll be writing exams, your board exams. Some of it is unpaid. At our firm as well, we are looking at an unpaid structure for the article clerks, but not confirmed yet. But having said that, you will need to balance your personal life, your working life, and your study life. It's something you have never done in law school, but it is part of the journey of becoming a lawyer. Final thoughts are, labor law exists because it is meant to correct the power play between employer and employee. You need to take your professional development very important. It's more competitive out there now. And if you want more information from me, go on to any social media platform, Facebook, Instagram, TikTok, LinkedIn. Research legal leaders, and you'll see videos of me there. I do live sessions like this very often. I have probably 2,500 or 3,000 videos online. So I know some students also comment that it gives them helps them with their first case at the CCMA and things like that. So that is my short session, 20 minutes. If anyone has any questions, please feel free to ask.
Any question, guys? Yes, Tulufelo.
Morning. Am I audible?
Yes, you are.
Okay, I would like to ask that I recently read that there's a possibility that you could be employed under a certain company and you're not aware, and they're using it for their own benefit in terms of UIF, which might make you struggle to get employment. So, in such instances, what then do we do? Because I checked on these a little it's star 134 something for labor law where you can actually check your employment status. So I want to know that after checking and you realize that you actually are employed under a certain company, but you're not aware, what's the way forward with that?
It's an unusual question. The way forward would be to write to that company and say, it seems to me that I'm employed by you. The best way to check was the Department of Labor. So go to the Department of Labor website, put in your ID number and register there. You'll see your employment history. And if anyone has employed you, take them to the CCMA for an unfair dismissal case. Tell them what's the story here. So catch them at their own game. What's the next question?
Temba, you can go through.
Good morning. Thank you, Aslam, for the insightful information. I have one question here. Under South African labor laws, what are the implications for employers who require candidate attorneys to own a vehicle and speak fluent Afrikaans? And how are these requirements evaluated in terms of fairness and potential discrimination? Thank you.
Very, very good question. It's a very good question. The law has changed now. You should not have a requirement to ask for a driver's license and ask for owning a vehicle. That has gone away now. That's against the law. So if you see any adverts like that, screenshot it and send it to the LPC. So they will write to that person and say they're not allowed to do that. The LPC is a governing body of lawyers. Now, it doesn't mean you must go and spy on everyone. No one likes spy like that. But what it means is sometimes law firms are just not aware and they won't listen to you if you write to them and say why you have this requirement. But as soon as they get a letter from the LPC that says, hey, you ran an ad where you requested someone to have a vehicle, that's not allowed. Guaranteed they won't do it again. So in terms of the language requirement, I'm not entirely sure if that's discriminatory because sometimes the clients of the law firm speak a specific language, and that is an advantageous skill to have. So I don't recall seeing anything from the LPC about a language requirement. Okay, what's the next
question? Nick, did you have a question?
Yes. Good morning once again. My question is, I am not sure if any of you are aware of the group chat on Facebook called the Candidate Attorney Support Group. Like I see a lot of anonymous people posting about their experiences doing their articles this year, and which begs to the question of harassment when you touched on the how the candidate attorneys are being harassed by their employers. So it makes me like wonder what is it, what is the problem basically, because there's a post which I saw from one of the candidate attorneys saying that they are required to do their duties as a candidate attorney. They are required to be a cleaner. They're required to be a personal assistant of everyone in the firm, including other senior candidate attorneys. So, and then when you read the comments, you can see some of the attorneys are saying like it's building experience. It's because you're a candidate attorney, so you need to learn so that when you manage your own law firm. So is the problem the principal attorneys or the law firms, because this is it not harassment in such a way, and what is maybe something that you can do to try and prevent that? Because if you're going to report that, maybe they will say you don't want to learn because you're still a candidate attorney, so you just have to enjoy the harassment and just suffer in silence? Because that is what we are seeing.
Yes, it's a good question. That's why I decided to speak about harassment as well. It's a very common issue that is facing a lot of candidate attorneys. Now, I keep coming back to the LPC because that is the regulatory body that governs attorneys and advocates. I said earlier that, if there is an issue, first talk to your manager or the director of the firm and say, this is what's happening. I don't feel comfortable with it. Can you ask this person to stop it, or whatever the situation is? If the harassment continues, then you have no other option but to go to the regulatory body. The LPC is generally quite a fair body. They have a fair system of rules and procedures that applies to all attorneys, advocates, and clients as well. It's meant to protect the profession and also protect clients as well from unfair treatment. So if you are being treated unfairly and you've tried to resolve it internally, then your next step would be to go to the CCMA or the LPC. Now, the LPC, you can just phone them and get a series of steps from them. When I said earlier, don't be a spy, what I meant was you can't go to the LPC because your boss shouted at you and used a raised voice. That is not, the LPC will say that's not what we deal with. The LPC's jurisdiction is also not harassment per se, but it does deal with unprofessional conduct. So if you can frame it in the sense of unprofessional conduct and what's happening at work to you, then they might entertain your claim and also give you some guidance as well. So I would suggest it's a fine line, but at the same time, you do have options available too.
Thank you. Leo, you can ask your question.
Good morning, everyone. I hope you're all well. Thank you for the session. My question is based on the minimum wage thing, and I bet everyone, almost every candidate, attorney, or law student is always curious about it. You hear, oh, someone is earning 2,000, 2.5. And what interested me was the fact that you pointed out the issue of minimum wage in South Africa. You're saying other countries, they don't have labor regulatory bodies, something like that, right? And here in South Africa, we have there's labor laws that are governing, the power play between an employee and an employer. And you mentioned that one of the students said the minimum wage is 8,000, right? And you also mentioned that when a candidate attorney gets articles, they sign two type of contracts. Please correct me if I'm wrong.
Oh, you are right.
Okay, yes. An employment agreement as well as the one for articles, something like that. So it's two contracts, right? My question is, if they are signing an employment agreement, are they not protected under employment laws, like labor laws and everything, and they shouldn't be subjected to this really, I don't know, I can't find a real word for it, like this 2.5s, like so much money, like some others are even getting 1,000 something, others are not even getting.
Okay, Leah,
What's
thank
the
you for your
question?
question.
Yes.
I think the question is around the minimum wage.
Oh, so what is the LPC saying about that in terms of, because it looks, yes, it takes principles to say no, just because you experience, so just take whatever it is that I'm giving you.
Okay,
Yeah.
no, LPC has issued the minimum wage to be 8.5. I stand to be correct. It's around 8.5, 8. Also, it depends on urban and rural areas. The employer has no obligation but to comply. Simple as that. If they don't comply, go to the CCMA, contact Department of Labor, or go to the LPC. There's no discussion for that.
Thank
What's
you.
the next question?
Lungile.
Good morning, everyone. My question, it goes back to one of the colleagues here who asked about where there is an advertisement which says that you need to have a car and maybe also speak Afrikaans. So I just wanted to know if it amounts to an unfair discrimination. Let me say a certain firm advertises their position for a candidate attorney. They say you need to speak Afrikaans and you need to have a car. Or maybe let me put away the Afrikaans part. You need to have a car, and then someone complains at the LPC, and then they change their advertisement. They say car is not a requirement. But then when they shortlist their candidates, they shortlist people who have cars, and then they end up hiring someone who has a car. Will that amount to an unfair discrimination?
How will you prove the discrimination and unfairness?
Because they first they advertised that they want someone who has a car, and then they ended up shortlisting people who have cars, and then end up appointing someone who has a car.
Okay, let's assume that they don't do the advert, because now I see less of those adverts. Your question is, what if they don't put it in the advert, but they hire someone with a car anyway?
Or
Will
they
that
ask
amount
during
to
an interview, or they can ask during an interview if you've got a car or a driver's license or something like
They
that,
should
and
not
their
be able to
preference.
ask in an interview. They should not be able to ask in the interview, because that is still giving an unfair advantage to candidates who don't have a car. So it is you'll have to prove unfair discrimination generally is quite hard to prove at a CCMA level. So the long and short is, without letting it become an academic discussion, if you see an advert that is requesting for vehicle and license, it's not allowed. That's the long and short of it. Whether you bring a claim for unfair discrimination and all of that, I think that it will be hard to comment on. It becomes an academic exercise. Let's just stick to the principles for now. Where's the next question?
Okay, thank you. Karabo?
Good morning to everyone, and good morning to you, sir. My question is more based on opportunities in labor law instead of like the things that happen. I just wanted to ask whether the only opportunities that you find for labor law are in the CCMA, because nobody really elaborates on what you can go for in terms of labor law.
Usually the opportunities, the good paying opportunities, are to work in companies. So like a big company like Standard Bank or FNB or mining companies, insurance companies, because they will pay you a salary to manage all the HR and IR functions of labor law. So that is stable, solid employment. The CCMA, we often find the biggest problem you have is the people that need to hire you don't have money because they were unfairly dismissed. When someone is fired, they don't have money. That's the reality of it, because they need to pay their bills and budget accordingly. So it's not often seen as a lucrative field, if that makes sense, to practice in. But if you want to know where the money is, join a company, specialize in labor law, and then go up the ranks within the company to become a legal director or something like that. But first, do your articles.
Thank you. Songezo, you have a question?
Okay, maybe we'll leave it the next 5 minutes for questions, Elizabeth.
Yes.
And then we'll end off from there, right? So maybe the next 2 questions, and we'll end off.
Okay. Songezo,
Okay.
you can ask your question.
Can I ask a question? I just
Please.
needed some clarity on how to approach the LPC. Like, since it's the last resort, where does it start? Like, for example, if there's an issue at the workplace, firstly, do I begin speaking to the manager? What is it followed by before I can go to the LPC?
What type of issue is it?
So what I have experienced, because I once worked at a law firm in Alberton as a legal secretary, it was more of bullying. So there was a lot of bullying, shouting, being told that I'm very incompetent, or get papers thrown at me, things like that. I stayed
It's
there
very
for like 3 months.
surprising. It's very
Yeah,
unprofessional and surprising to see things like that happen because, this is someone who has studied 4 years. Not to say that people who haven't studied should be treated badly, but you expect, like your boss or your principal or manager, someone who's put time studying to understand, to have an educated mind, not to treat people this way. But the first step would be to talk to them first and record that meeting from your cell phone, because in terms of the RICA Act, you are allowed to record if you're a participant of that conversation. And if that doesn't work, send an email, a written complaint. If that doesn't work, CCMA or the LPC. See, it's a hummingbird. So that would be the steps that you would have to take.
Okay,
Thank you. One
thank
last
you.
question. Songezo, you can ask your question.
Good morning everyone. Am I audible?
Yes.
Okay. My question, I just have one question that I want to ask. So I would like to ask that what are skills that are crucial for effective negotiation in labor disputes?
Very good question. Excellent question. To be honest, I think you need to be a good litigator. That means you need to be able to be willing to fight, because labor disputes is not easy disputes. It is not you're going to walk into the CCMA and get money paid to the employee. You need to be a fighter. That means you need to be able to be confident, to be able to be outspoken. You need to be able to, you can't be a softie, because the employer and the employer's organization will just walk all over you. So someone who is confident, outspoken, and not afraid to speak up. That is what I found is the key traits of a labor. It's very similar to criminal law. Very similar to criminal law. You need to be able to be strong and handle the clients.
Thank you, Aslam. Thank you for coming through and sharing your insights with the student. We really appreciate it so much, and we have
For all
learned
the
a lot.
claps. So
Yes,
many claps
thank
on
you
the
so
screen and
much.
I feel like I'm on
Yes.
a TikTok live right now.
Yes, you are. Yes, you are. We
Yeah.
really learned a lot today, and it was a very engaging session. So we have taken I think 1 hour from your vacation, so now you can go on and enjoy your vacation, and good luck. Thank you.
Yes, and before I hand over to Jennifer, I
Yes.
also wanted to thank you for the opportunity to have me today. And like I said, if anyone needs more information, just check us out on social media. Jennifer is a very respected family law practitioner. I remember as a student, I attended one of her lectures. So that shows you that you're not dealing with someone who's junior in the field. This is someone, when I was a student, 12, 13 years ago, I attended one of her talks on family law. And the fact that she made time today, that means a lot. I hope you guys absorb everything she tells you.
Definitely.
Thank you so much, Aslam. That's such a lovely compliment. And yes, I'm a lot older than you, so that was 12 or 13 years ago. I can't believe it that I was lecturing you. Well, I hope I gave you a love for the law.
Well, definitely. And also a reality of family law. That's why I decided to go on labor law. Okay, everyone. Have a good one.
Okay, cheers.
Enjoy your holiday.
Take care.
Bye.
Okay. Bye.
Okay, Jennifer, the floor is yours.
Thank you very much, Elizabeth. I'm just going to get my slides going again.
Okay.
Can you all see my slides?
Yes.
And you can all hear me?
Perfect.
Okay, fantastic, guys. I'm going to kick off then and just welcome you all to the session. And thank you to Elizabeth for inviting me to chat to you guys today. It's I've really been looking forward to it and excited about it. Excited about it. And the fact that all of you are here today really just shows me that you take a specific interest in the law, and you've given up a bit of your weekend to actually listen to our talks, to Aslam and my talks. And I think that's really a good quality for you guys to have, especially when it comes to looking for articles and all that kind of thing. So I'm just going to talk a little bit about myself, and not too long because I know it's the weekend. So these are all my contact details. The slide should be moving along. So I'll take you through everything. In terms of social media, you might already have linked into me. So I have a personal site and a Jennifer Skoltz attorney on LinkedIn. And then my Facebook page is Jennifer Skoltz attorney. So if you guys are on Facebook, I generally give family law related posts. So new case law, some funnies, what's happening in the courts in terms of family law. So if you do enjoy it, then that's a good place to, a good page to like. And then I also started a group quite a few years ago called Lawyers Rule. It's also on Facebook. And Lawyers Rule now has 42,000 members, so it's really grown. And what Lawyers Rule will be nice for is a general grasp of the law, because we have all sorts of attorneys, we have students, we have candidate legal practitioners. So you're going to find there a lot of interesting questions posed by attorneys from a practical point of view. Also, job vacancies are put on their vacation programs, which, I know you guys might be interested in to get a bit of experience. But it's really a wonderful group to be a part of. So hopefully you can join that group as well. And then I've given you all my details there if you would like to contact me or anything like that. So a little bit of background. I started a long time ago with my articles in 1992. So that just shows how aged I am, but hopefully a bit wiser by now. And I studied at UCT. Then I went on to do my articles. I know there was a lady who didn't have such a good experience with articles who's in the room. I'm really not going to focus though on articles. I'm going to focus specifically on family law. But what happened in my articles, it wasn't fantastic. I had didn't have a very nice boss. And so I decided after articles to go into academia. So I started with UNISA. I was there for about 10 years. And then I decided to, because my other passion is family law, I decided to open my own practice. So Jennifer Skoltz attorney has been going on for about 17 years now, coming up for 18. And we specialize only in family law. So my thinking when I opened my practice was, don't try and do all kinds of different law. Rather do one kind of law and become known and specialized in that particular kind of law, because family law is a very different type of law to specialize in. So, you know, that's what I thought, is don't be a jack of all trades, rather focus on a specialization. So I've got a small practice, but very busy. It's a boutique sort of practice in Fourways. And I have one other attorney in my office. And then I also have 2 candidate attorneys. And just in terms of my candidate attorneys, they really learn things from, you know, grassroots upwards. So as much as they, you know, they answer the phone and they open files and they do some scanning and copying, they don't drive around all day doing errands and that kind of thing. They sit in with me with clients, they deal directly with clients, they draft all sorts of pleadings and letters and notices. So that's how I like to treat my candidate legal practitioners. On the issue of cars, which I don't want to go into, they both don't have cars. They're both from a disadvantaged background. They're absolutely amazing clerks. So I've got a good team. And yeah, so they don't have cars, but the thinking when they came into the interview is, let's not make that a negative thing. So they approached me, they said they don't have cars in the interview, and they suggested other ways that they could get around, you know, to go to court and those kinds of things. So what we do is they catch taxis to work, and then I Uber them for work travel. So if they're going to High Court, they'll pop in an Uber. It's also a lot safer than taking your own car into town. So try and make your interview a positive one, as opposed to saying, well, you know, I don't have a car, so I don't know what to do. Make it a positive one. And yeah, that's just a little bit about my candidates. And then I also lecture for 2 of the big law firms. So I lecture for Weber Wenzel and ENS Africa. They also do the lead, the PVT, the practical vocational training courses. And then I've also been with the Law Society for about 13, as Aslam said, about 13 years lecturing for them in various subjects. I'm also on the radio regularly on Metro, which is quite daunting because, you know, there's about 5 million listeners. So if you say something wrong, then you know that 5 million people have been listening to you, which is quite scary, and it's quite nerve-wracking. So yeah, so that's just a little bit about who I am. And I'm going to kind of kick off now with the family law aspects. So this is just a little brainstorming session. We'll take about maybe 3 to 4 sort of reasons for divorce. So I just wanted to know from you, what, in your opinion, what do you think that the reasons for divorce could be in South Africa? Anyone want to hazard a guess?
Hi, Jennifer.
Hi, how are you?
I'm good. It's Elizabeth. So I'm thinking finances might be one of the causes for divorce.
Good. Very nice. That's finances is a very good one that you've mentioned. So especially during COVID, people lost their businesses or they got their salaries were reduced and that kind of thing. And that's led to a lot of problems with people's finances that they're not able to sort out. Good. Who's next? Sorry, I
Yes,
can't see
Mandla.
your hands when I've got
No,
my
it's fine. I
slides.
can monitor the hands. I will monitor the hands,
Thanks,
Jennifer.
Elizabeth.
Don't worry. Mandla, you
Thank
can
you.
ask your question. Or you can answer the question. Sorry.
Yes, I was about to
Mandla?
say Hello?
Yes, we can hear you.
Hello, I can hear you.
Yes, ma'am. I was about to say misconduct by either of the parties. maybe
Good.
cheating.
So cheating is always a big one. The courts, unfortunately, in the past, cheating and adultery used to be a ground for divorce. Now the courts are of the opinion, that misconduct isn't a huge problem in divorces, which is morally quite disheartening. But yes, we have a lot of people cheating. Thanks, Mandla.
Ngile, you can
Anyone
answer the
else?
question.
Good morning once again, everyone. My answer is that physical and emotional abuse to either or of the parties.
Very, very good. We have a lot of that. I do a lot of that domestic violence in my practice, and it's a very sad part of the practice. Yes, so there's physical, there's verbal abuse, there's drug abuse, there's alcohol abuse. So we see that a lot. So that's a good one. Thank you.
Esona.
Morning, everyone. I'd say, ma'am, that the irretrievable breakdown of the marriage because of lack of communication amongst.
Sorry, I'm battling to to hear. I don't know if it's my ears in my old age. Do you mind just repeating your question?
Am I audible now, ma'am?
Yes.
That's much better. Yes. Thank you.
Okay. I'm saying that one of the other factors is the irretrievable breakdown of the marriage because of lack of communication amongst other things.
Good. So we people, they don't sit and chat, they don't try counseling, and they're just not, they fall out of love, which is, you've really got to work on a marriage, I mean, well, mine's been 28 years, so, and there's not many divorce lawyers who not divorced themselves. So communication is key. Okay, so there might be a few more people, but I think let's move on. So we've talked about infidelity, finances, poor communication, abuse, and then no attraction is actually the fourth one in South Africa. So that's a problem. If you're not attracted to your spouse, that doesn't help your marriage either. All right, so I just wanted to go through a couple of slides here where I'm going to talk to you about I know this was one of my mandate really from Elizabeth, is what cases you would deal with on a daily basis in a family law practice. Okay, we don't have to go to each and every one because we have had a few questions that students have asked Elizabeth for me to touch on. So let me go through a few of the cases. And then maybe if you do have questions, we can take, one or two questions after my two slides, if that's okay. All right, so family law is a very interesting practice to be in. It's completely different, and it does take a certain type of person for them to enjoy family law. It's very emotional. The clients are needy. There's a lot of, as that gentleman said, abuse and that kind of thing that you have to deal with. So what we do is we do uncontested divorces, and we do a lot of mediation. So you will learn when you do your civil procedure. I've got a bit of an echo. Let's just see. Okay,
Sorry about that. I think it was one of the students. So I muted the students.
Okay, perfect. Oh, no problem. So you'll learn in civil procedure that mediation is now in the forefront of South African law. So we would always start with a possible mediation. So when the client phones us and says, no, they want a divorce, we would say to them, why don't you both come in and we negotiate a settlement agreement for you, which then avoids a contested divorce. So it's a lot cheaper and it's easier on the kids because their parents then remain friends and that they're not being pulled, between one parent and the other. Parental rights for unwed fathers. That's one of the big areas of my practice, is the unwed fathers. So as much as they've been given their rights in terms of the Children's Act, they still have to fight for their rights. So they're still not seen to be on a similar level to the moms. So we don't have unwed mothers in our Children's Act. We only have unwed fathers. So they still struggle a lot, and the courts are not sympathetic, unfortunately, towards unwed fathers. We do a lot of maintenance. So during divorce, post-divorce, we try and assist people with maintenance. Then people who they're not quite ready to take the leap to a divorce, we do separation agreements. So where they say, let's try it for 6 months or so and see if we can maybe reconcile. But in the meantime, let's, deal with the following aspects: the kids and who's going to move out of the home for those 6 months. Guardianship applications, also a lot of those. Wills, we do. Cohabitation contracts. I know that one of the students had asked a question on, whether there's a common law marriage in South Africa, which I'm going to deal with in another slide. So when people start living together, we always recommend that they enter into some kind of agreement, and we call that a cohabitation contract. People who want to change their regime. So you can change your marital regime in South Africa. For example, I've got a gay couple now who got married in Las Vegas. They didn't realize that in Las Vegas, you're automatically married in community of property. So now they've come back and they've realized that. So we're helping them now to change their matrimonial regime, because in community of property is obviously not a great way to be married. We go into a lot of customary law, which I'm going to cover. There was another question on customary law. Islamic law, we deal with, the Sharia system, and, there's been a great case that recently came into operation, in which the Constitutional Court said that people married in terms of Islamic law, their marriages are now recognized in South Africa. It's taken about 20 years, I think, to get to that stage. Ante Nuptial Contracts, that's the nice part of the practice, where people are all in love and wanting to get married. My lecturing I've told you about. So you can, when you become admitted in that, you can look at, if you enjoy lecturing, you can look at that angle. We do curatorship applications. So now we've got a boy who's he's 26, but he's got the brain capacity of a 4-year-old. So it's a very sad case. And his parents are now applying to be placed into his life as curators, because previously the banks and that were fine with the parents transacting on his behalf, but now people are saying, you need to have a curator to be placed as a curator to this child. We do a lot of relocation applications. There's so many people leaving South Africa at the moment, and then you get the situation where the one parent wants to leave with the kids, and then the poor other parent is sort of left behind. And we've got to look at, when can that parent see the children? It's expensive for that parent left behind to now travel to the UK or Australia, and the virtual contacts, like Skype and FaceTime, and it's a difficult type of contact for those parents, the parent left behind. Adoption and foster care. Foster care is a very rewarding part of my practice, and adoption. We have found with the courts with foster care that the state is very slow to allow foster care. So there was a little boy, he was put on the steps of the orphanage by the mom. We don't know who the mom was. So my client met him when he was 6 months old. She volunteered at the orphanage, and sorry, I just want to have some water. And my client then sort of fell in love with the little boy, and it took us 3 years to get that little boy out of the orphanage. And it was terrible. It was just such a fight. But also she got him when he was sort of 3.5. He was brought to court and then sort of handed over to her. And that was very rewarding for us. But it's sad that you have to sit in an orphanage when you've actually got a person who would just love to have you in their care. And now she's moving forward with the adoption. I'm not going to touch today on paternity disputes. Surrogacy is it's not a common part of my practice, because a lot of people don't enter into agreements for surrogacy when, for example, your sister's having your baby and that kind of thing. But what needs to happen is you need to have a surrogacy agreement. And in South Africa, there's no money that's allowed to change hands when you have a surrogate. Although I think under the table, people do that. And yeah, so you have an agreement with, what the surrogate parent's going to do when she sort of hands over the baby. What can the non-surrogate parents pay for? So it's just like medical aid and vitamins and the birth and the scans and that kind of thing. But as I say, not giving the surrogate, 100,000 Rand or something to be the surrogate. And then also not very common in the practice, but the aspect of artificial insemination. So where we have, for example, a lesbian couple at the moment, and one of them is going to bear the baby through an unknown sperm donor. So that sperm donor, obviously, they give up all their rights to the child when they donate their sperm. And the difficulty with this type of situation is that the mother who's not bearing the child is at risk, because the child's now going to be born and she has no blood relationship to that child. So our job is then to enter into an agreement which gets made an order of court that gives the other mom parental rights and responsibilities to that child. Because if that child were to, if there was a breakup with the marriage or the relationship, then at least that other mother has rights to the child. So that's not a common one, but it is something that we do look at. So what I'm going to do now is I'm just going to tell you what we will be talking about in a little more detail before you ask your questions on the cases that I do, because we might be covering that topic a bit later. So this is just a joke. It's finally over. Frank's lawyer got the apartment and my lawyer got the 2 cars and the beach house. That's what happens if you don't mediate. So that's what happens. The 2 attorneys just become rich, and usually the children have been pulled apart by the parents. I'm going to talk a bit, I'm actually going to focus on the questions that Elizabeth sent to me. So we're going to talk about African customary marriages and sort of case law revolving around that. And then someone also asked about the accrual and sort of how it works, the antenuptial with the accrual. So we'll just talk about that. I've given you a bit of an example about how the accrual system works. We're then going to move on to the Children's Act, which governs all children in South Africa. And someone had asked about the maternal preference rule. So do mothers have more rights in South Africa than fathers do? So I'm going to take you through what happens with the children in a divorce, what the contact or access is to those children, which is very generous now towards fathers if 2 people are getting divorced. Someone did ask about a common law marriage in South Africa. So I'll focus a little bit on life partnerships, and then we'll have some questions and answers. But I'm quite happy to take questions as we go through each of the slides. We'll just have to limit it because I don't think everybody wants to sit here for 2 hours while I waffle on about family law. So are there any questions on the cases that I do which I'm maybe not going to be covering in my talk?
Yes, Lungile.
Thank you. My question is on the Ante Nuptial contract. It also relates a little bit to maintenance. I wanted to check
Yes.
if it's allowed for, let me say I'm entering into an ANC with my fiance. We say that
Yes.
should our marriage dissolve in a form of a divorce, no one should be allowed or be entitled to ask for spousal maintenance.
Yes. So if you put that clause, you're saying if you had to put that clause into your antenuptial contract, whether you can or not.
Yes, I think that was the question.
Is that what you're asking? Okay, so what we in South Africa, we tend to not have those kind of clauses in antenuptial contracts because the contract is in contemplation of marriage. So things like, if one of them cheats or what will happen with maintenance, that's all in contemplation of a divorce. So you could put that clause into your antenuptial contract, but if there was a divorce, one party could argue that that clause is against public policy. So we tend not to put those kind of clauses into our antenuptial contracts. Does that answer your question, Lungile?
Yes, it does. Thank you.
Okay, that's a good question. Thank you. Any other questions? Or can I carry on with our African customary marriages?
Yes, you may.
Okay, perfect. Thanks for all the questions. It's always good to have some interaction. So in terms of African customary marriages in South Africa, in family law, you probably would have learned about the requirements and all that kind of thing. So I want to take you through it more from a practical point of view in a divorce situation. So what happens in a divorce situation is, for example, now we have a client who he wants to try and prove that his wife is actually not his wife in terms of African customary law and whether a customary marriage actually took place. Whereas the wife, who's represented by another attorney, she wants to say there was a marriage, and especially because they're married in community of property. He's very wealthy, my client, so he doesn't want to give the lady 50% of his money. So it's quite sad. We're managing to settle it by saying to our opponent, let us give you an amount, R1 million or something, even though it's not half of his estate. So we're trying to settle that. So what we would do is we look at the statutory requirements in terms of the Recognition of Customary Marriages Act, which is very old, which actually needs to be updated, I feel. And the general sort of requirements is the couple must be over 18. They should have consented to the marriage. And then the marriage was celebrated and negotiated in terms of customary law. So a handing over of, the discussion with the families, a celebration, all that type of thing. Bearing in mind that your clients would come from different tribes in South Africa. So for every tribe, there's differences in terms of what sort of constituted a customary marriage. So the judges, they also need to look at that and get experts in, say from the Swana tribe or the Zulu tribe, if there's a divorce, and work out, what was actually important in that specific tribe. So someone did ask about the issue of lobola. So that's always a difficult one because the general feeling, and I did do a radio talk on the double HP case. You might have been familiar with that, with the rapper double HP. We'll chat about the case. So generally, the law says that lobola is not a strict requirement. So in the double HP case, for example, he'd only paid a third of the lobola. But the court said there that his intention to pay lobola was there. And just because he didn't pay the full lobola didn't mean that there wasn't a marriage. So the judge did order in that case that Lerato was his customary wife. And then there's another thing that can also happen is you can register your marriage, which you should do within 3 months of marriage. You should register it with Home Affairs. And if you have done that, it makes your case really strong in court because your intention was actually to get married. It doesn't have to be a proper marriage certificate or anything. In our case, we've just got a handwritten sort of contract between the two of them that they took to Home Affairs, and it was stamped by Home Affairs. So in our case, the wife has quite a strong case because they have registered their marriage and they meet the other requirements. So every case in African customary marriages is different, and that's why we struggle so much with judges who, they make sometimes rash decisions as to whether this person is married in terms of customary law. So what most people are doing now is they are coming to us and signing an Ante Nuptial contract. This was actually the question. So before your customary marriage, you come in, you sign an Ante Nuptial contract. That's to the reason you're going to sign it is so that you're not married in community of property. And then most people now are doing the civil marriage as well as their customary marriage. But bear in mind that you must sign your ante nuptial contract before you have your customary marriage, because otherwise you will be married in community of property. Then you'll have to try and change it. If you guys, you might remember the double HP case. So what happened is it went into urgent court. Literally, double HP died and his funeral was the Saturday, and it went into the urgent court at like midnight on the Friday before the funeral. So there the judge, we didn't have it wasn't my case, but they didn't have experts. They didn't have, registration of marriages. The issue of lobola was actually raised in that case. So double HP's dad was holding the funeral, and Lerato, the wife, came to court and said that she should bury double HP because he is her customary husband in terms of the law, and the dad was obviously saying he had the right to bury double HP because Lerato wasn't the customary wife. So the court looked at the requirements, but without having experts because there wasn't time. So everything was adhered to in terms of the requirements, but the one issue was the issue of lobola. So double HP's father said they're not married in terms of customary law, and the one thing he raised was the lobola. So he said double HP hadn't paid the full lobola, therefore there should be there should not be a customary marriage because of the lobola. And then Lerato was obviously saying he'd paid a third, and therefore he is her husband in terms of customary law. And the judge decided in that case that there was a customary marriage. The case was highly criticized, and it's gone on to appeal. Some people thought that it was decided too quickly as to whether they did have a customary marriage or not, and that the issue of the lobola was sort of secondary to the other requirements. So that's what happened there. You probably would have seen in your family law books, you probably did family law maybe in second year, you would have seen in your family law books that there's a lot of case law about African customary marriages, and each case, unfortunately, is different. Would anyone like to ask some questions or maybe give us some comments, maybe from personal experience as to African customary marriages?
Yes, Samukelo, you can ask your question.
Thank you.
Good morning, everyone. Am I audible?
Good morning.
Yes.
Good morning.
Hi, Jennifer. My question is it possible to register a marriage when the husband, a customary marriage, when the husband is paying the lobola in installments, or must the full amount be paid first?
No, so that's a good question. So you can still, in terms of lobola, you can still be paying it in installments. So the marriage can be registered regardless of whether the lobola's been paid, whether it's been paid in full. You can still register your marriage within 3 months of that marriage, of the celebration and that having taken place.
Oh, okay.
Does that answer your question?
Yes, it has. Thank you.
Thank you for that. Anyone else?
Hey, I seem to be asking a lot of questions today. I hope you don't mind.
No problem. I like
Um,
questions, so it's no problem.
yeah, my question is something I know that it has never happened, but I just want to ask if it may be arguable in as far as developing a customary law. So
Sure.
let me say on a certain Saturday, I decide to go and pay lobola for my fiance. And then part of the negotiation, we negotiate that no, this marriage should be out of community of property without the ANC, and it is recorded. But we haven't entered into an ANC, an actual ANC before a notary public. Will it be arguable, let me say, comes divorce and we say no, actually this marriage was out of community of property, will it have a prospect of success?
Look, you could. I like your question. You would have to have a lot of proof that you intended it to be out of community of property, and the difficulty you would have is that any antenuptial contract should be registered in the deeds office. So generally, they're not seen to be verbal. But we did have 2 cases last year, in fact, that pertain to your question, in which a verbal antenuptial contract was allowed. They were very strange cases. They've both been taken on appeal. But there they said there was enough proof by the couple that an antenuptial contract existed. So they had spreadsheets they'd done, for example, just before the marriage of which assets would form part of the accrual, which assets wouldn't form part of the accrual. So there they actually allowed a verbal antenuptial contract, which would then give the situation you're talking about, would actually hold weight. But you would have to have proof. So not just saying to each other, let's get married with an ANC. It would be delving into the terms of the ANC and that kind of thing. And in fact, in one of the cases, they called in the priest who had, or the elder, or whoever had married them at that point in time, and basically said, usually before a marriage, you get told about, well, civil marriages, you get told about the different types of marriages. And so they called in the elder to say, did he discuss that with the couple? And he gave evidence to say that he did discuss it with the couple, and they chose to have an antenuptial contract, but they didn't ever get it registered. So you would have a case, but as I say, it would require a lot of proof. Does that answer your question?
Oh, yes, it does. Thank you so much.
Thank you very much. Let's take one more question on this, and then we can move on. Who's next, or is there another question?
Any question, guys?
Shall we move on?
Yes, we can move on.
Okay. All right. So this one, I know you've done in quite a lot of detail in family law, depending on which campus you're with. I believe you from a variety of different universities, which is great. So someone did ask about the antenuptial contract with the inclusion of the accrual. So how does that contract work? So I'll just tell you quickly. I think one of the first things with antenuptial contracts when you're in practice is that you should bring in the future husband and the wife, or with homosexual marriages, the 2 guys or the 2 girls. And you must give them, it's ethical to give them both advice about the antenuptial contract. So you mustn't meet with one of the parties and then the other party just signs the antenuptial contract and doesn't know what they're signing. So ethically, that's a very important thing to do. And then we'll just talk about the antenuptial with the inclusion of the accrual system. So basically what happens there is you would ask your clients about the assets that they have. And I've just listed for you a few of the assets. So it could be, land or a house, a motor vehicle, pension funds. That's another whole area of the law. So now these days, the Pension Fund Act caters for the other spouse to take 50% of the pension fund. Unit trusts, retirement annuities, all those could be seen to be assets. So what we do if there's a divorce is maybe I must start with the marriage. So in your antenuptial contract, you can specify a commencement value. So that might be money that the future husband has in a bank account in London. Or you can specify excluded assets. So you could say your motor car mustn't be included in the accrual. Okay, or your pension fund, you can exclude it up front, but then you must exclude it up front. Otherwise, if you don't, then all the other assets go into the bubble, which is the accrual system. So you mustn't be confused. So when you marry with the accrual, a lot of people, even senior attorneys, think that what you had at the outset of the marriage is yours, but that's not the case. So whatever you had at the beginning of the marriage, you must specify whether you want it to go into the accrual or not. So what we do if there's a divorce, usually it's an easy calculation. If it's not an easy calculation, we send it off to a forensic, to an auditor or an accountant to work out what the accrual actually is. And I think a large part of the problem when we do divorces is where one person hides their money. It's very difficult then to try and mediate and get an uncontested divorce. So people who hide their money are definitely problematic. So what we do is we take the assets, we write do a spreadsheet, then we take off the commencement value that they had, so that must go back to that person. We take off any excluded assets, and then we also deduct things like inheritances, gifts, donations. Those are never included in the calculation of the marriage. They always belong to the person who who inherited. And then we take off all the liabilities. Sorry, I've had flu, so I'm swine flu, which was awful. And then we take off all the debt. And then once we've done that, we get what the accrual is. And then that accrual gets divided by 2. So what we say is, when we do our calculation, who is the wealthier spouse? And the wealthier spouse would then give 50% of the assets to the poorer spouse. So if this poorer spouse happened to be let's say the husband, because these days it doesn't matter, it's the husband or the wife. Let's just say it's the husband. If he's got R1 million and the wife has no, then he would end up giving half of that R1 million to the wife in the divorce. So he would get 500,000 rand, and then he would lose 500,000 rand, and the wife would come out with 500,000 rand. So that's basically how we work out the accrual. It's not a bad system of marriage. It works quite well. The problem comes in, and that's when people fight. When, say, one of them is cheated. So say the wife's cheated, and now the husband has to give her 500,000 rand of his money. Okay, he's not going to be happy to part with that money. And that's when we get, contested divorces. So that's basically how it works. Are there any questions on the accrual system? Is everyone okay? Maybe it's not a very popular part of family law.
Yes, Tulu, you can ask your question.
Yes.
Okay, it's probably not fully part of this contract, but I want to ask if during divorce they had an agreement that 50% of each goes to the children once they have
Yes.
retired, and then this person passes away, and unfortunately they have more children outside the union that he once had. So how then does it work out? Because now they're going to share the pension fund with other children, or do you have to now present the divorce agreement where it was stated that 50% will go to the children that were part of the union? That's just what I want to know.
Yes. Okay, that's a good question. So what happens when there's a death? So just say, for example, the death and the husband is the one that passes away. What we do is the very first thing that happens if there's a death is the accrual gets calculated. So if we take our example of the 500,000 Rand, the first thing that happens is the wife gets her 500,000 Rand. So she's covered. So then the accrual is sorted out. Then we would take the 500,000 Rand that the husband had when he died in terms of the accrual, and we would then divide that 500,000 Rand either in terms of his will, so who he left his money to in terms of the will, or if he didn't have a will, we're going to divide that 500,000 Rand in terms of intestate succession. So, and that's where if he had maybe 2 kids from the marriage and he had 4 kids from outside of the marriage, then we would look at, we take all of those 6 kids and divide his 500,000 Rand up if it's intestate succession. So you don't have to worry about the divorce agreement, because first of all that gets calculated. So, and then only his 500,000 Rand gets split either by the will or by intestate succession. I'm not sure if that makes sense. It's quite a complicated area of the law when there's a death and there's a marriage. Does that make sense to you?
Yes, thank you. Thank you very much.
Thanks. That's a good, a complex question, but a good one. Any more questions on this topic? Should we move along?
We may proceed. Oh, ke lebogile.
Perfect.
There are
Okay,
questions
perfect.
coming through.
Oh, sorry. Yes.
Good morning. I wanted to ask a question in terms of the Ante Nuptial contract. So let's say me and my partner, we recently found employment, and but we want to get married. And then the family says they are willing to assist us in terms of the marriage. And then we want to sign the Ante Nuptial contract. What will be drafted, because we won't have property, or we've just started to find employment?
Yes, so that's a good question. So you're starting out, so there are no assets or anything. Then normally what we would do there is we would just, in our contract, we would say that you start with a null value because you don't have any value in bank accounts or things like that, because you haven't started working yet. We start then with a null value, and we start with no excluded assets, which means then that everything you all the profits you have during the marriage, less the liabilities, that would all form part of the accrual. So you don't start with anything, you start from fresh on a clean slate. Does that make sense?
Yes. Nice.
Okay, excellent. Shall we move on?
I think Mandla had a question. Mandla?
Mandla, we mustn't forget about Mandla. Yes, what is
Yes.
your question?
Yes, ma'am. I'd like to ask, in terms of the previous question, the one before this one, the lady asked, who asked about, sorry, what was the question? Who asked about the marriage agreement, the divorce agreement, about
Yes.
the division of estate. Yes, that one. I wanted to know, will let's say the written divorce agreement take precedence over, let's say, interstate succession?
So, yes, so it doesn't take, it would first take precedence because you're going to work out who is owed what. So from there, it's a formal deed. So you would first work out who owes what. And then you would, if it'd been a divorce, you're asking if there was a divorce before the husband died or not, or just about the
No,
death.
no, ma'am. I'm asking in terms of like the same. Yes, yes. In terms of the death, he didn't have a will, and then he also has other kids outside the marriage.
Yes. So first we do the calculation of the accrual when he dies, and then in that case a will takes precedence. Once we've done the calculation, a will then takes precedence over intestate succession. So first we would say, is there a will? If he left everything to his wife or his girlfriend or whoever it may be, his 500,000 Rand would be divided in terms of the will. And if there's not a will, then it gets divided by intestate succession. Very dangerous thing not to have a will. Does that answer your question, or did you want a different sort of angle on that one?
Oh, yes, ma'am. I was asking specifically in terms of, let's say, that divorce agreement that in terms of a divorce, or should one of them die, 50% of their, let's say, I don't know, what was the question again? Accrual, something like would go to the children. Yes, I was asking in terms of that agreement specifically, not necessarily a will, but would that agreement in comparison to the children who are outside the marriage, would that agreement take precedence?
So that if they got divorced, then that agreement would first be used, and then if he died thereafter, then it would only be his money that would be then divided up. But the divorce agreement would take precedence. Does that
Okay,
answer your
thank you very much.
question? Sorry, I
Yes,
think I
ma'am,
was
thank you.
misunderstanding what you were asking, but thanks for that question. Should we move along now?
Yes.
I think we should, because I don't want us to, I don't know what time, Elizabeth, you would like it to finish. Did you have a time in mind or not?
We added an extra hour if we can end it by either 1 o'clock or 1:30.
Or 12? Are you meaning 12 or 12:30?
Yes, round about that time. Yes,
Okay.
12 or 12:30.
Perfect. Okay, because I tend to, because I love family law, I tend to, babble away a bit. All right, so I've just given you an example of how to work the asset split in, in practice. So that's kind of how you would work it. And as I say, if it was very complicated, you would often get an accountant in to work out what is the calculation, because most lawyers aren't very good at maths. I'm specifically not good at maths. All right, so we're going to just look at the Children's Act, not in a lot of detail, but just in terms of, what happens to children in the case of a divorce. And remember that every family is different. So, and that's the nice thing about family law, is every couple who comes to you for a divorce, they've got different children, they've got different ways in which, they bring up their children. Some people have special needs, children who need to then be dealt with in a different manner. So what we do is, as lawyers, we don't know what's in the best interests of the kids. So if it's a very complex divorce in terms of the kids, we would often get a social worker or a psychologist in to do a report. And we also have someone called the family advocate. That was also one of the questions. So the family advocate is a government institution, and they have a family advocate at each of the different courts. And the family advocate, if it's something complex and the parties are fighting and they can't agree on what happens with the children, you can use that government institution to work out what should happen to those children, and they'll do an investigation. So it's a bit confusing. They're called the family advocate, whereas a family lawyer or a family attorney would be someone like me. Okay, the family advocate is specifically the government institution that helps with the kids. And the only problem with the family advocate is they're overworked. So it often takes a long time to get an investigation done by the family advocate. So if our client has funds, we often rather use a private social worker or psychologist. So with the children in the divorce, I've got to try and affect the children as little as possible with the divorce. And the judges have started getting very strict when it comes to people fighting over children. They've started putting spouses in jail, where the spouse is denying the other spouse contact with the children. So it's often the mom, unfortunately, where she says to the dad, you're not going to ever see your children again or something. The judges have started putting those moms actually into jail for 3 months because they're denying the father his rights. So what happens in terms of the law is, you probably know already, but we have guardianship, which is the big decisions that have to be made, relocation, whether the minor is going to start a business or enter into contracts. That's all to do with guardianship. And then we have something called care of the children. So we used to have those words which were used in the olden days, where we had custody and we had access to the children. Those words were done away with. So now we have care of the children, and that is the old form of custody. So the care is the day-to-day decisions that need to be made for the children. So their discipline, which school they're going to, if they need an operation, both parents have to consent. So the law says for guardianship and care that both parents have that automatically. So it would only be in the case of a a drug addict, who's not prepared to try and remedy things, where that person, might not have decision making over that child because he or she can't make decisions because of their drug addiction. Otherwise, it goes to both parents. And then what the court does is they say, where will that child primarily be living? So the court wants to know, and the family advocate wants to know, where that the child has a stable home. So we either have primary residency, and all moms want to be the primary caregivers. And that's where the person's question comes in. So is it only moms who get to live with their children most of the time? Or can dads also have that right? So the courts are supposed to, look at it and say each party should have primary residence. We also have something called shared residency, which is becoming very popular. So shared residency is where if you have a 30-day month, for example, each parent would have that child for 15 days of the month. So they might have the child for a week. So the mom has a week, the dad has a week. Or I don't know what it is, but some people have these really complex shared residency where it's 3 days with the mom, then 4 days with the dad, and every weekend they each alternate weekend they get to have the children. But shared residency is becoming very common now, and it's practically, I don't like shared residency, so it's not one of my favorite things, but if the kids are very little, shared residency doesn't work that well because they're pulled between two different houses, and a lot of little kids need their mom and their dad, so they would battle to not see their other parent for that week when they're with the parent. But shared residency for older kids, if they're 10 or 11, it often works very well. And then each parent is happy because they get the chance to have their child living with them for half of the time. So yes, so shared residency can work, and it's very popular now in South Africa. And then someone asked about nesting. Unfortunately, I apologize, but I haven't been able to look at the case law yet. I just didn't have time this week. So what I will do for that person, and perhaps Elizabeth can share it with the class, is I will do a little, sort of write-up on the case law in terms of nesting and whether it's working in South Africa. So nesting is where the couple have one house and the children always live in that house. What the parents then do is each parent has their own property as well. So they might have a flat or something like that. And then the parent has time, has their time with the kids in the house that the kids live at. So the mom, for example, would come for her week. She'd come and she'd live in that house with the children. Then she'd go back to her flat, and the dad would come to that same house and have his week with the children. Okay, it's not something that any attorney likes, and it also leads to a lot more expenses for the couple. So if they're very wealthy and they can afford to keep the house and have their own houses or flats to live in, then it's fine, because it's nice for the kids to stay on in the family home. But generally, it's a very strange thing, and it's also an invasion of privacy to those parents, to have a house that they always go to. So I'm not sure what you guys think about nesting, but for me, it's not a good option. And when I take questions, we can just maybe talk about your views in terms of nesting. So the child also has a say now. So this has become very popular, to take the child's view into account. So when they are 12 or over, they have the right to sit with a psychologist or a social worker and talk about who they would want to live with and why they want to live with that parent. But kids are, sometimes they're problematic because they get manipulated by, for example, the dad, and the dad says, you know, I'll buy you a PlayStation if you say that you want to live with me. Okay, or the mom's been saying, you know, your dad's abusive and he's nasty, and you must tell the psychologist that you want to live with me. And the reasons that the child has to live with a particular person must be in their best interests. So if the dad is the fun person, and the dad's sorry, I've lost my chain of thought. So if he's the fun person and the child says, well, I like my dad, I like to live there because he doesn't make us do homework, and we go to McDonald's and we get presents and clothes and that kind of thing. The court's then not going to say, well, yes, then you can live with your dad, you know, because maybe the mom does their homework and makes them, you know, homemade meals and all that kind of thing. So even though the child has a say, it has to be legitimate reasons for living with that parent. And the courts won't split children up. So if there's two siblings, you know, and the one says, I want to go to my mom, and the other one says, I want to go to my dad, they've got to work out, you know, a place where both those children can go to, because they don't like to split up siblings. Then the parent that doesn't have the primary residence with the child. So the primary residence can go to the mom or dad, but we still, in our law, sadly, the family advocates and judges and that kind of thing still favor the mom, even though it's, you know, the Children's Act came in 2007. So things should be improving for the dad. So what we do for the dad, if the children are living with the mom, is we arrange very generous contact for the dad. So it used to be in the old ages, dads used to get like a Friday to a Sunday twice a month. So they saw their kids for 4 days out of a 30-day month. So that's now out the window. So if you're mediating and the mom says, I want, you know, every second weekend, you know, you then need to step in and say, you know, dads now have generous rights of contact. So I've just given you some examples there. So they might have every second weekend, and then during the week, they might have a 1 or 2 night sleepover every week with the kids. So maybe they're seeing them, you know, 10 days a month, or so it's not 15, but it's, you know, 10 or 11 days a month, which is much better than 4. And then we also cater for, you mustn't just leave it at the weekends. You've got to cater for public holidays, Mother and Father's Day, you know, birthdays that will now be shared between the parents, the actual parents' birthdays as well. And then we also say to our clients, when you don't have the kids, make an effort to phone them. There's so many virtual ways of contact these days. You can Skype, you can FaceTime, you can WhatsApp video. So this shouldn't take the place of physical contact, but it should be in addition to the physical contact. And there are some moms who they'll tell the child to turn their cell phone off so the dad can't get hold of the child, you know, to have telephonic contact. And I'm not saying that all moms do this. We have because that's a generalization. We have moms who are very encouraging and help, the dads to see their kids as much as possible. And they get a break. So, then they don't have the children 24/7. They have a little break where they can do their own thing. So that's, in short, that's how the children work when it comes to a divorce. And maybe we can take some, 2 or 3 questions on the children in the case of a divorce now. Would anyone like to ask something? Any questions? Or are you
Yes,
getting
Temba.
tired now? Temba, yes.
Hi, Jennifer. Thank you for the session.
Hi.
It's very insightful.
I'm so
Finally,
glad.
I get to hear your voice. This question is in terms of the judicial discretion. How much discretion do judges have in modifying court orders related to childcare and access, and what justifications must the judge provide when exercising such discretion? Thank you.
Thank you. So that's a good question, because remember, the courts are the upper guardian of all minors. So the court relies heavily on the family advocate and, what the family advocate believes is in the best interests of the children. But they can go over that and use their judicial discretion. So what is happening now with the judges and the magistrates and that kind of thing is they're asking that the children come in and have a session with them in their chambers, so in their offices or whatever the case may be. So the kids come in. It's a little bit intimidating for children, but the judge tries to make it, as comfortable as possible. And this would be if, the parents were unhappy and they said they're not happy with the family advocate report. The judge would just sit with the children for an hour or so and see what's going on, and then either go with the family advocate's report or make his or her own decision relating to the children. So judges are becoming a lot more proactive now in terms of sorting out problems when it comes to the kids. Does that help you?
Yes, it does. Thank you. I actually do have a follow-up question, but this
Sure.
is in terms of the financial cost. Like, how does the court typically address the financial concerns of parties in appointing experts like the psychologists and other experts in terms of helping the families and the child? Thank you.
Yes. So what the courts do is we have state social workers and psychologists who work for the family advocate's office. So if you have a couple who, they're not wealthy or whatever the case may be, then they would be appointed a state psychologist or social worker. Those people are also very overworked, unfortunately. So that also takes a time to investigate. Otherwise, what a judge would normally say is that if there's a social worker, private one appointed, that the parties must share it 50-50. Sometimes, though, if say the dad wants the investigation to be done by the private person, the dad might say he'll then cover those costs of the investigation. But it's normally 50-50 to make it fair on the parties. Is that what you're asking?
Yes, that's what I was asking. Family law is so interesting. I actually have so many other questions. So I'd like to ask one last question.
Yes,
Recently,
sure.
recently I have written an article about unmarried fathers. So
Oh, wow.
in this article, I'm actually discussing a case between um two parents. So let me just ask the question. I'll share the article later.
Yeah.
So what are
Yes,
the
I'd
implications?
love to see your article.
Okay, I'll send it. I'll share it with you. So
Thank you very much.
the question is, what are the implications for unmarried fathers in different countries when trying to assert their parental rights, and how does the law affect the well-being and stability of the child involved? Thank you.
Okay, so are you talking about when they, like one parent's in South Africa and the others in the UK or something?
Yes, it's a similar scenario. Basically, what happened is that the father, both parents are South Africans. The father was in the US when the mother was trying to relocate to the UK. So when the father found out, that's when he started to contest for the childcare.
So he said he wants the child to go to him and not to relocate with the mom.
No, he was not happy that he was not informed that the child is now moving to the UK, and also that
Yes,
he was not being granted access to the child.
to the kids. So
Yes.
yes, so that's a very difficult situation in South Africa. And I won't go into detail on unmarried fathers, but they're often left behind. You know, so we have our Children's Act, but then the father has to prove certain things to get his rights, which is, you know, shouldn't be the case. Um, so a lot of the moms will just do their own thing with the kids. So they'll say, I'm taking the kids on a holiday, or you can't see the child this weekend because, you know, they're sick, or I'm choosing the school for the child and you have no say. So it actually involves, you know, fathers actually having to go and get a court order to help them with their contact. And I mean, in your situation, did the father did he already have his rights to the children? Did he have a court order, or is he sort of just the father with no court order in place to assist him?
Initially, there was no court order to assist him in terms of his parental rights, but they were established by
Yes.
the court.
Okay, so they weren't, or they were
They were
established.
established by the court.
So what we normally do in a case like that is we would take the South African court order and we would do what we call a mirror order, MIRROR. And the mirror order would basically then be made a court order in the countries where the parents live. Okay, so the dad could get the order made, a mirror order where he is, and the mom could get it, well, she might not want to, but she can get it made a mirror order in the UK. And that means then that the rights are entrenched not only in South Africa, but also in those other countries. So that's the best thing to do, because otherwise, if he's not happy about the relocation, he would have to launch an application in the place where the children live. So if he had moved to the UK, he would have to bring a whole application in the UK, which would be very expensive. So that's how you would have to do it. But you know, probably in your article you've covered it, but fathers have a very tough time, unwed fathers. Does that answer your question?
Yes, it does. Thank you very much.
Okay. And you'll send the article, you'll share it with me, hey? You can email it to me.
Okay, yes. Can I share it on LinkedIn?
Perfect. Yeah, LinkedIn or my email address, it's on the slides, because you guys can take, you know, you can have my slides to read from as well.
Okay, that's great.
Thank you very much.
Thank
Are there
you.
other people with any questions? Are we okay to move on, Elizabeth?
Yes, we can move on.
No, we have one question
Okay,
from
Yannick.
Tulu.
Okay, one more question.
It won't be long. It's a story
No
similar
problem.
to, it's something similar to Temba, but with a little bit of a twist. So during divorce, the mother runs off with the children. Father files for sole custody, in which he gets custody of the children. And then later on, when they reconcile and decide to cooperate, through their verbal agreement, the father allows the mother to have the children, but she later on turns around and runs off with the children. So what does the father then do? Does he then rely on the sole custody that he has? And will the 3 months imprisonment apply to the mother? Or will then, because they can't burn the mother from seeing the children, they obviously have to, be a little bit lenient. So I just don't know what then happens in that situation.
Sure. So in your situation now that you've given me, the dad has sole custody, and then the mom has just got, he's given her some contact with the kids.
Mm-hmm. Yes.
Okay, so in that case, remember the court order will always stand. So you can always fall back on your court order. So if he was given sole custody, but he then allowed the mom to see the kids, and then the mom said no, the dad said no, you're no longer seeing the kids. Unfortunately, he can use the court order for his sole custody or whatever contact arrangements were in that court order. So it's a tricky one, because he then has the power. So he could say to the mom, you're not going to see the kids except in, what's been given to you in terms of the court order. Does that answer your question, or am I off track?
Yes, you've answered my question, but I also want to know, since you've mentioned the 3 months imprisonment that applies, will it then apply to the mother for breaching the agreement between the two?
So you're saying the mom runs off she takes the children?
Yes.
Okay, yes. So if she takes the children, the dad would have to bring an urgent application to get those children back into and he would use his sole custody agreement to get those kids back. And if she takes them within South Africa, he must get his kids back. Some people kidnap the kids and then take them overseas. And then it's a whole different story, where the kidnapping rules and that have to come in. Does that help you a bit?
Thank you. Yes, you've answered me.
Thanks for your question. I think let's move on, because I think we've been an hour and a half, so I'm sure you all needing a break as well. Shall I do life partnerships? Do you guys have time for me to just touch on that?
Yes.
Okay, let's do it, because it's an interesting topic that someone raised. So in South Africa, the general rule is we don't have a common law marriage. So overseas, we have, in the UK especially, we have what we call common law marriages. So if you live with someone, in a stable relationship for longer than 6 months, then you're deemed to be married in community of property. So it's very dangerous. And we don't have anything like that in South Africa. So, we have clients who I've got one now where she's lived together with a man for the last 17 years. He's a coach at one of the soccer clubs in South Africa. And recently he broke up with her. And he basically said to her, and she was left with nothing because she had not worked for those 17 years. She brought up the kids. So she's not entitled to any remedy in the law because they're not married. So she can't get maintenance for herself or anything like that. Obviously, he still maintains the children. They'd also bought things together, but unfortunately, she paid towards things, and then he put them in his name, like the house was registered in his name and that kind of thing. But she'd done renovations, and so basically what's in his name is his, and what's in her name is hers. So what we have to do for that client is we have to prove that the two of them had a partnership, and we call it a universal partnership. So what we're going to claim for her is we're going to say that they were partners during the marriage, so they had a contract of partnership, and that she should get 50% of the assets. So you don't automatically get this. So we have to institute an action to prove that they were married, that they were partners. And the requirements, if you've done contract law and you've dealt with partnerships, the requirements are similar to a business partnership. So that each of you brought something into the relationship. So even if the mom, my client, she looked after the kids for 17 years, that would be her contribution towards the partnership. His is more of a financial contribution. And then that the partnership was carried on for the joint benefit of the partners. So they both benefited from the fruit of the partnership. The object of the partnership was to make a profit. So when they entered into their cohabitative relationship, the object was for their sort of relationship to flourish and to make money and make profits during the relationship. And then that the contract should be legitimate. Okay, so it mustn't be something that's a relationship that's unlawful. And then some of the other things the court looks at is they look at whether it was a continuous relationship. So in this case, if you'd gone out for like 4 years and then you had a 5-year breakup, then you got together again. Your case might not be as good as 17 years, of a continuous relationship. And then the court also looks at, was it monogamous? So in other words, that you didn't have other partners during that relationship. So that's what the court looks at. And there's been a lot of success with life partnership claims where people have been given 50% of the estate. But as I say, it's not automatic. So you actually have to bring an action to prove the life partnership. Are there any questions on the life partnership?
Yes, we have one question. Mandla, you can ask your question.
Mandla.
Yes. I would like to know, in terms of, I'm actually interested in terms of the element, the requirement that it must be entered for intentions to make profit. I'm actually wondering, how do they satisfy that requirement when it's a relationship?
So, yeah, that's quite a difficult one to satisfy. So what you would look at there is, for example, if they looked at, instead of renting a house, they looked at, using their money to purchase a property. So to better, to sort of better their situation. It would be that kind of thing. Or they, just trying to think of another example. They renovated their house so to make it, more profitable. Things like that. They maybe bought more, agreed to buy more expensive cars. So as they sort of flourished financially, they tried to make a profit in their relationship, opposed to having a lot of debt. That kind of thing. But it's, it is hard to prove. Mandla, does that help you?
Okay, thank you. Yes, ma'am, you've answered my question. Thank you.
Thank you. Is there another question?
Any question, guys?
Okay, so guys, it's been really a pleasure to chat to you. I feel like we've covered quite a lot. I hope it hasn't been too long for you. And if you're at local universities and you ever, you'd like a chat on, or a session, a practical session on, I don't know, relocation or ante nuptial contracts or whatever the case may be, please let you can let your lecturers know. And I'm very happy to come and do some sort of presentation, a case study or something like that, to make your theory, to take your theory and put it into practice. And I think one of my candidates might talk to you in the future about the positive aspects of articles of clerkship. So what are the good things? Because we tend to focus on, the salary and not having a car, and, as opposed to focusing on articles and saying, it's a good experience and you learn a lot and you meet people and you go to court and you consult with clients. So there's a lot of good aspects of articles, but you guys are starting in the right place by being mentored and listening to discussions and that kind of thing. So yes, so I appreciate that, and I commend you on that.
Thank you, Jennifer. Thank you for coming through and sharing your experiences with the students and myself. It was a great session. Unfortunately, it has to end, but I'm sure everybody has a lot of questions, because family law is fascinating and it has different scenarios where things are tackled differently, even if the contents are the
Yes.
same, but each matter is dealt with on its own merits. So yeah, thank you very much for coming through. We appreciate
Oh, it's a pleasure, Elizabeth. Thanks for having me. And guys, have a good long weekend. I'm sure you've got some varsity work to do during your weekend, but keep up the good work.
Thank you. Thank you. Enjoy your weekend too, your long weekend, Jennifer.
Thanks, everyone.
See you.
Okay.
Bye.
Bye.
Thank you, everybody, for coming through. See you. Bye.
Thank you. Bye.
Bye.